Hello, my name is Rawia Ayanche, and I will be presenting the variation seminar to you today. Okay, so today in this seminar, we will discuss the basic principles, the essential principles. We will talk about some legal principles and examples of cases and some landmark judgments. We also might touch upon some finer aspects here that might help you identify some important points in contract or programming. And finally, we will talk about when alarm bells need to ring in your heads and some commercial considerations to disputes and seeking legal advice as well. The inevitability of change. Variations are changes to works that still fall within what's considered during contracting. Construction is dynamic. No project exactly follows the original plan. Changes happen due to design development, unforeseen conditions, and client needs. What is a variation? A variation is a change to the scope under the contract. That could be additions, omissions, alterations to the works agreed upon. Variations can impact cost, time, and risk allocation if not managed well. They often lead to disputes or budget overruns. So the goal of today's seminar is to equip you with the legal and practical tools to handle variations precisely and efficiently, minimizing conflict and preserving project objectives. Risks of poor variation management. We've got cost overruns. Uncontrolled variations can significantly increase project costs, erode profit margins and contingency sums. Delays. Changes not promptly integrated can delay completion, for example, waiting on approvals or redesign, risking liquidated damages or disruption claims. Variations are also a common source of contract disputes. Disagreements over scope, entitlement, or valuation often end in adjudication or litigation if not resolved. There are legal pitfalls. The failure to follow contract variation procedures may avoid the contractor's claim for payment or time unless saved by estoppel or waiver, as we will discuss. And precision is key. Proactively managing variations through clear processes, documentation, and communication reduces these risks and keeps projects on track. So poor variation management is one of the fastest ways for a project to lose control of cost, time, and scope. Unmanaged variations don't just change the work, they change the risk profile of the entire project. Definition of variations. A variation is any change to the agreed scope, whether by addition, omission, or alteration, made in accordance with the contract. In construction, a variation is simply a change to what was originally agreed to be built and how it was to be built or when it's to be built. A variation only arises where a change to the work is instructed or approved under the contract. So typical forms of variations may include additions of new work, omissions of certain works, substitutions of materials or methods, or altering the quality, sequence, or dimensions of work. Now, in standard contracts, there are specific provisions that empower principals or the superintendent to order variations, and without such a clause, an owner cannot unilaterally require any additional work. When a valid variation is ordered per the contractor must perform the change and is generally entitled to an adjustment in the contract sum and or time as per the contract terms. Examples include increasing the number of HVAC units, changing paint type, altering foundation design, or can be variations if ordered under the contract's mechanism. So what can be changed? Within the original scope, variations should relate to the project contemplated by the contract. So these could be minor changes, improvements, or deletions of part of the work are expected. Qualitative changes. These changes relate to specifications or materials, switching, finishes, design details, and these are commonly allowed if still part of the same overall project purpose. Quantitative changes are changes in the quantity of work, increase or decrease, and these could be adding additional units or omitting a section within reason. Extra work of a nature or labour to the original contract can be added via variation. Example, extra room in a building contract, subject to any limitations. Some contracts do cap the value of additions, which we'll talk about later. Variations can also omit work, so deleting work no longer needed. These are allowed only if not done to give that work to a third party, and we'll cover this important limitation within the case law. So what does the law say about variations? Not a variation within the contract. The case of Walker versus Council of Municipality of Randwick, the contract was an entire contract to build the wall for a fixed price, and that the plaintiff's obligation to complete the works for an agreed price was not affected by the alleged understatement in the plan, and therefore he was not entitled to recover payment for extra work occasioned. Now, this seminar is a bit short to go further than discussing how the work is treated if it isn't a variation, but we did want to identify broadly two categories of not a variation. So in the case of Walker versus Council Municipality, Mr. Walker contacted the council to build a concrete wall for a fixed price, which involved the removal of a sandbar shown on a plan to be around 6 feet in width. The plaintiff built the wall, but the width of the sandbar to be removed was claimed to be approximately 12 feet, requiring twice the work to remove. Now, just moving on to the next case, not a variation outside the contract. In the case of Blue Circle Industries versus Holland Dredging, the contract was for the purpose of dredging of certain areas of harbour to allow for larger ships to dock. The dredging company was originally to release the dredged material in certain areas, but the plan then changed to use the dredged material to build a bird island instead. Now, although the contract contained a variation clause, the court considered that the requested change was not a variation because the bird island was wholly outside the scope of the original contract. So in this instance, the court considered the contract vitiated and required payment on a quantum merit basis. Now, vitiation isn't the only outcome possibly for a variation, but I think I'll have to leave it at that because discussing everything that might arise from the work, which aren't a variation, go beyond this short seminar. Variation clauses. So a couple of cases there. Wigan Constructions versus Swadonga Sewerage Authority. Traditionally, the purpose of a contract is to make sure that once the parties have agreed on what they're going to do, one party can't change their mind and not abide by the agreement. They have to follow it, and that's what the law of contracts is essentially about. Variations are an exception that allows the party to say, once we get into the project, here's the process for providing an alternative solution if the one we've included in the original contract isn't desirable, but the parties can only vary the contract based on what they considered in the original agreement. So in Wigan Constructions versus Swadonga, Wigan was contracted to build sewerage works for Swadonga Sewerage Authority. After the contract was executed, Wigan was requested to expand the sewerage works considerably, with the original 47 house connections increased to 91. Substantial increases in both the total length of the sewer and areas to be built below the 4 metres depth, requiring 90% more concrete. The contract held a variation clause. However, it also contained the following limitation: the extent of all such variations shall not be without consent of the contractor, be as such to increase the monies owed, otherwise payable by more than a sum which is the percentage stated in Annexure A of the contract sum, or if not stated, by a reasonable amount, but no amount was stated. Wigan claimed that the works were not a variation, as the variation clause in the contract made provision for that they should not be bound by the rates under the contract. The court held that the additional works involved such a substantial change to the project that they effectively vitiated the agreement and ordered those works to be paid on a quantum merit basis. So any variations must be made pursuant to the variations clause to be validly made as variations. Now, just looking at variation powers in the case of Carr versus J.A. Berriman, a builder was engaged to both conduct construction works and fabricated building materials. The fabrication of building materials was a substantial component of the profitable work and affected the overall pricing. The contract provided for an architect, Mr. Osser, to be able to vary the contractual works. Now, after the contract was on foot, the principal essentially instructed the architect to vary the contract to remove the building material steel fabrication component of the construction works from the subcontractor and bring in a very different supplier who was cheaper. Now, the court considered that the variation clause gave the architect the power to vary the contract, but said that the principal couldn't actually just order the architect to do so, because that would be against the spirit of the contract. To actually be the independent decision, it had to be the independent decision of the architect. Now, as an aside, often the standard contracts will provide a variations power to the superintendent, and this is a handy one to be aware of. So, what is not a variation? An out of scope changes that is fundamentally different from the original project is not a variation, but a new contract or requires a mutual agreement. The contract's variation power can't be used to, say, build a completely new structure unrelated to the works. Implicit work, also not a variation. Work that is necessary to fulfill the scope, that is not a variation. These include correcting an omission in the design that is required for completion. For example, if a contract is to build a 100-metre wall and the design mistake the length as 90 metres, the contractor must still build the 100-metre for the same price file. The extra 10-metre is not a paid variation since it was part of the original contract intent. Contracted means methods. Directions on how the contractor performs work, if not affecting the end result, are generally not variations. If the contract doesn't specify a method, the contractor is free to choose, and the principal cannot insist on radically different methods without a variation order. What for? Outside the contract's purview. Work completely outside the contractor's scope, requested by the principal, isn't governed by a variation clause. The contractor can refuse or negotiate separate terms. We'll see cases such as Wren and Emmett, where the contractors were not obliged to perform such extra contractual work without a new agreement. What's also not a variation is work after completion. Generally, you can't vary a contract after practical completion unless the contract expressly shows post-completion variations. Legal principles, variation powers and limits. At common law, an owner has no automatic right to demand variations beyond the contract. Rather, a variation clause is needed to empower changes. A contractor can insist on the original scope if no such clause exists. Even with a variation clause, power is not limitless. An instruction that can fundamentally alter the nature or size of a project can be a breach of contract or even repudiation. The courts will read limits of reasonableness into broad variation powers. The cardinal change doctrine, not an official term in Australian law, but conceptually, you can't use a variation clause to essentially create a different contract. So large-scale additions or deletions may exceed the permissible scope, and we'll see examples in Wigan and Chadmax. Reasonable limits. Some contracts explicitly limit variations not to increase or decrease the sum by more than a reasonable amount. Even if it's not stated, courts imply that extremely large changes are beyond the intended scope of the variation clause. Good faith and fair dealing. The principal's power to vary must be exercised honestly and for the purpose of the project, not to undermine the contract. A variation cannot be pretext to remove work from the contractor improperly or to avoid contractual obligations, and doing so may be unlawful by the principal. Just looking at the case of Wigan Constructions in Swadonga. So the facts were the contractor constructs sewers, the superintendent issued variation to increase excavation by 60% and the sewer length by 40%, which would raise the contract price by 40%. The contract's variation clause expressly prohibited variations increasing the payable amount by more than a reasonable amount. And the issue before the court was this anomalous increase a valid exercise of the variation power. The court decided that it was not, and that it exceeded the permissible scope, and it held that the instruction wasn't a variation allowed by the contract, such that the change was so large that it violated the clause's built-in limits on cost increases. Also, by ordering an impermissible variation, the principal repudiated the contract, such that the contractor could terminate. This underscores that reasonable limits exist. A clause cannot be used to force exorbitant changes. So what's the principle in Wigan Constructions? It sets the reasonableness limit. A variation clause may allow flexibility, but there is a threshold, whether it's explicit or implied, beyond which change ceases to be a true variation and instead is tantamount to a new contract or a breach by the owner. So variations by omissions, limits and risks. Contracts often allow the principal to omit or delete work via variation. However, this power is limited in key ways by law to prevent abuse. No sham omissions. An omission cannot be used to simply take away work from the contracted party and give it to someone else. The court's view that this is beyond the scope of a fair variation, essentially a breach of contract if attempted. The Berriman principle, as established by the High Court in Carr v. Berriman, even if the contract says work may be omitted at the architect's discretion, it does not authorise omitting work for the purpose of engaging a different contractor to do that work. Such action would be unreasonable and could only be conferred with very clear words, and also standard contracts don't allow it. Genuine reductions only. Omissions should be genuine reductions in scope. For example, the owner decides not to build a feature after all for legitimate project reasons. If the owner simply finds a cheaper contractor for a portion of the work and tries to omit it from the main contract, that is not a valid variation. It's likely a breach. So the limit on total omissions, likewise, an omission that nearly cancels the contract, taking away most of the work, is not a valid use of the variation clause. It could be treated as repudiation, as we'll see in the Chadmax case. So just moving on to the case of Carr v. J.A. Berriman. This case involved a contractor construct a building. The clause allowed the architect at his discretion to issue written directions to omit any work. During the construction, the owner, through the architect, omitted all structural steel from Berriman's scope and got a third party to supply it. The court determined that it was not a valid variation. It held that the architect was not authorised to delete work just so it could be done by someone else. The variation power did not permit such a substitution of contractors. The key quote in the case to remember is that the omission clause did not give authority to delete the works so that they could then be carried out by another contractor, absent very clear words. Such a broad power would be unreasonable and was not intended. The implication of Carr v. Berriman is that the owner's attempt was a breach of contract. The contractor was then entitled to damages, loss of profit on omitted work, and the courts will strictly construe omission powers. They cannot be a backdoor to cut one contractor out and bring another one in. In the case of Commissioner for Main Roads and Reed, similarly, an owner engaged a third party to supply materials, topsoil, instead of paying the contractor for extra as the contract contemplated, and it was held to be a breach of contract. So even a small portion of work omitted for reletting is not allowed. So size doesn't matter, the no degree test or timing test. Another important case, Chadmax Plastics versus Hansen and Youngkin. Chadmax was a subcontractor to apply specialty finish on an office tower. The head contractor allowed a change of finish. The owner decided not to use wall flex and directed the main contractor to change the wall finish. This resulted in 98% of Chadmax subcontract being deleted, since almost all their work was applying wall flex. So the issue was, can a main contractor invoke the subcontract variation to delete virtually the entire subcontract scope? And the court found no, deletion is too expensive. So the court said that this was a variation in name, but in substance a cancellation of the subcontract. So by omitting 98% of the work, Hansen and Youngkin had repudiated the subcontract. So Chadmax was then entitled to damages for a breach of contract, essentially losing profits on the portion of the works removed. The variation clause did not give power to virtually cancel the subcontract. So the principle here is that where an omission is so large that it defeats the purpose of the contract, using a variation clause to omit nearly all of the work is beyond the scope and is treated as a breach or repudiation. It must be remembered that a variation clause gives power to vary, not to abandon a contract. Okay, so moving on to contractual procedures, written orders. To be enforceable, variations must be properly instructed as per the contract terms. Usually only the superintendent or architect or someone authorised in writing by them can direct a variation, and it often must be in writing or confirmed in writing. For example, the AS 2124 clause 40 or the AS 4000 clause 36. Variations must be directed in writing by the superintendent. Verbal instructions should be documented in a variation order. And if the contractor performs work without a formal variation or instruction, it risks being considered volunteer work, unless later ratified. So as contractors, they must insist on a written variation, direction, or written approval before executing changes that affect cost and time. If a signed instruction is given orally, promptly submit a confirmation or notice to have it recognised under the contract. Ensure the person giving the direction or change actually has authority under the contract. For example, instructions from a client's project manager might not count as the contract designates them or the superintendent ratifies it. Record keeping. Keep clear records of all variations, number them, retain emails and letters. This provides a paper trail to support payment claims and time extensions later. So, notice and time bars. Notice requirements. Many contracts require the contractor to give notice of variations or claims within a specified time. For example, notify the superintendent within 7 days of a direction if the contractor thinks it is a variation, or notify any cost or time impact within X days. Some contracts state that a failure to give timely notice extinguishes a contractor's right to claim extra cost or time for that variation. These are often called time bars clauses. For example, a clause might say that a claim is not payable unless a contractor submitted a detailed claim within 28 days of instruction. Strict enforcement. Australian courts often enforce clear time bar clauses. They are not considered penalties, but agreed risk allocations. So missing a notice can mean no entitlement, even if work was done, unless an exception applies. So adopting best practice, always issue required notices on time. Even if you don't have full details, send a prompt initial notice reserving your rights, then follow up with details as allowed. This protects your claims. So what's the superintendent's role? The superintendent should promptly communicate written directions and note when a contractor notifies a claim. A prudent superintendent will also remind parties of notice requirements although the onus is on the contractor. Keeping the process transparent can prevent later disputes on where a variation was notified. So when procedure isn't followed, the estoppel and waiver principles. So in practice, strict compliance with variation formalities isn't always followed. Work changes can be informally agreed on site. However, ignoring the contract process is risky. If a dispute arises, the party in breach of the procedure, often the contractor not getting written approval or missing a notice, could lose their claim unless equity steps in. So equitable doctrines such as estoppel and waiver can sometimes rescue a contractor's claim for a variation despite non-compliance. Essentially, if the principal or their agent leads the contractor to believe that a variation was paid, even without formal paperwork, and the contractor relies on that to perform the work, the principal may be stopped from denying payment on the basis of a technicality. If an owner or superintendent by words or conduct represented that a variation is approved or will be paid and the contractor relied on it to their detriment, the court might also prevent the owner from insisting on the strict contract requirement of a written order, otherwise known as promissory estoppel. Similarly, an owner might waive the requirement for strict compliance, either explicitly or implicitly. For example, if the owner consistently tells the contractor, just do the work and we'll sort the paperwork out later, they might be found to have waived the formal notice requirement. However, there are limits to these avenues. Estoppel and waiver are not automatic. The contractor must show clear evidence of reliance on the principal's representation. Also, many contracts now include a no oral modification or anti-waiver clauses, and these can complicate or limit the ability to claim estoppel. Though not always a full barrier, it raises a bar of proof. Okay, just moving on to case of Update Constructions versus Roselle Childcare. The facts in this case, the contract required written variations. However, during the project, numerous changes were directed informally by the architect. The contractor carried out these variations without strict written orders, under the impression they would be compensated. The issue before the court was the owner later refused to pay for some changes, citing lack of written variation claims per the contract, and the question was, could the contractor recover despite non-compliance with the written notice clause? The New South Wales Court of Appeal held the principal was stopped from relying on the absence of written variation approval because the principal's architect or agent had conducted themselves in a way that led the builder to proceed on the changes. The owner, having accepted the work, could not use the technical defence of no written order to avoid payment. Another important case, BMD Major Projects versus Vic Urban. BMD was contracted to a development project, formerly a quarry site. Unexpected conditions and changes arose, and the contractor did not comply with some of the contract procedures for variations. The principal initially indicated flexibility. So when the costs escalated, the principal tried to enforce the contract strict conditions to deny BMD's claims, arguing that the contractor's failure to meet the notice and claim requirements. BMD argued that the principal had waived or was stopped from enforcing the requirements due to the principal's conduct in encouraging the work. The court found in favour of the contractor on certain claims, accepting that the principal's conduct constituted a waiver of strict compliance in some instances. In BMD major projects, the onus actions, such as continuing to direct work and engage with the contractor on extra work without enforcing notice timelines, indicated that it would not insist on the time bar. Thus, the owner could not later ambush the contractor by invoking it. Now, the exact details are complex, but the case reaffirms estoppel and waiver can override time bars in the right circumstances. Okay, so work outside the contract. beyond the variation clause. Sometimes the owner requests work that is completely outside the original scope, something that is not contemplated by the contract at all. In such cases, the variation clause might not apply because the work isn't a modification of the contract of the work, but an addition of a new task. Now, if asked to perform the work outside the contract, a contractor can decline since it's not obligated by the contract, or negotiate a separate agreement, either a new scope and price. But performing it without a clear new agreement is risky, and payment isn't guaranteed under the original contract. So Wren v. Emmett illustrates that when the owners wanted extra work not in the contractor was in a strong position to negotiate fresh terms. Chief Justice Barwick noted that a contractor approached for extra contractual work may refuse unless a satisfactory new arrangement is made, and an owner who tries to insist otherwise is in breach. Implied or quantum merit claims. If a contractor does extra contractual work on the owner's request without a formal contract amendment, the courts might allow quantum merit, or otherwise known as a reasonable value claim, but only if certain conditions are met. For example, clear owner requests, knowledge outside the contract, and an expectation of extra payment. Absent those, the contractor might do the work for nothing, and that's a dangerous situation. So the best practice is don't treat major scope creep as a mere variation. Insist on a contract variation deed or supplementary agreement for the works that fall outside the original four corners of the contract. This ensures clarity on scope, price, and time for the new work. Trims v. Mina. This is a case about a builder, Mina, who did several extra items of work on a residential project at the owner's Trims request. Such changes that were arguably outside the original scope. There was no written variation order, and the owners believed the changes were at no extra cost. When disputes arose and the owners locked the builder out, the builder claimed payment for variations as extras. So Mina sued for the value of additional works, arguing that they were payable as variations under the contract or on a quantum merit basis since they were outside the contract. So the court decided that the contractor's failure to recover most of the extras. The Court of Appeal found there was no agreement to pay beyond the contract price. The owners had not agreed to any added payment. The works were not proven to be of greater cost or value than the original scope, and the criteria for implying a separate contract or restitution were not met. So moving on to standard form contracts, the AS 2124, a widely used traditional construction contract in Australia, but it's now been superseded by the AS 4000. In AS 2124, Clause 40 governs variations. So just looking at that particular clause as an example, under that variation procedure, the superintendent can direct a contractor to perform variations to the work. The directions must be in writing except in emergencies and can include additions, omissions, or changes in the quality of work. The contractor is obliged to comply with the written variation orders. So AS 2124 provides that variations are to be priced using rates or prices in the contract, so far as they are applicable. If not applicable, then reasonable rates or prices are to be agreed or determined. The contractor should submit pricing if requested, but the superintendent then certifies the appropriate adjustment to the contract sum. The contractor is entitled to an extension of time if a variation delays completion, provided that the contractor notifies delays as required. So AS 2124 links the EOT clause with the variations, and the contractor must claim an EOT within the contract timeframes when a variation affects the critical path. So in terms of notice requirements, AS 2124 typically requires prompt notice from a contractor if it believes a direction is a variation. There's often a provision that if a superintendent gives an instruction the contractor considers to be a variation, the contractor must notify if not instructed as a variation already. This helps avoid later argument whether something was in scope or a change. Okay, moving on to the AS 4000. The updated Australian Standard Construction Contract, the variation clause is in clause 36, and it has evolved from the AS 2124. So in clause 36, superintendent before practical completion may direct the contractor to alter the works. So, for example, add, omit, change character, quality, or execute additional work. Directions must be in writing. If the contractor receives a direction that isn't clearly identified as a variation, they should ask for clarification or give notice if it will require extra payment. Now, similar to the AS 2124, use contract rates if relevant, otherwise reasonable rates, prices. The AS 4000 explicitly allows for contract sum to be adjusted for variations as agreed or assessed by the superintendent. If a variation results in an omission and reduces the cost, the contract sum is decreased accordingly. But remember, limitations cannot omit to give others. The contract doesn't permit that implicitly. So AS 4000 also places emphasis on communication. It typically requires a contractor to notify within 28 days of becoming aware of any event, including variations. This will incur extra cost or delay as a precondition to claim an EOT or costs. And non-compliance could bar claims through some clauses, allow superintendent's discretion to still grant an EOT. So the comparison of this clause to the AS 2124, the AS 4000 removes the old defaulting procedures and is more straightforward. It doesn't require a contractor to formally acknowledge a variation direction as that AS 2124 did, but the best practice is still to confirm instructions, and AS 4000 has a clear dispute resolution provision if there's a disagreement over the variation value. Okay, standard form contracts. ABIC, another commonly used contract. It's usually used for architect-administered building projects. It has a more client-to-architect interactive process for variations. So just looking at the variation process under the AIBC, typically the architect under the AIBC can issue a variation order or a direction for a variation. However, uniquely, the ABIC often allows the owner to initiate a variation request, which the contractor then prices. The architect will then issue a written variation instruction only after the owner approves the price and time implications. So in many of these ABIC contracts, if an owner wants a change, the contractor provides a quote. The owner then can decide whether to proceed. If the work is varied without an agreed price, perhaps due to an emergency, or if the quote process is waived, the ABIC provides that the costs be valued by the architect fairly, often using market value or rates, and the contractor is entitled to a reasonable profit margin on the extra work. The ABIC variation forms typically document the instruction, the agreed price adjustment, and any extension of time granted for that variation. This formalised process aligns with best practice. Fewer surprises later. Unlike the AS contracts where the superintendent can unilaterally instruct and sort prices out later, the ABIC leans towards a consent-based variation system. The owner is involved in approving the variations and their costs before implementation, which can reduce disputes about payment since the price is often agreed upfront or at least known. Okay, so moving on to best practices, procedural discipline, 5 takeaways. Know your contract. First and foremost, understand the variation clause in the contract you're administering. Different forms have different notice periods and mechanisms. Make a checklist of the requirements, so the written direction needed, the time to submit quote or claim. Point 2, ensure all project staff, engineers, contract admins, site managers are aware that they mustn't perform changes without proper authorisation. They should promptly report any requested changes to the contracts team to get a formal instruction. Pre-work clarification. If there's any ambiguity whether something is included in the scope or is a change, seek clarification in writing. It's better to resolve up front whether it's a variation than argue later. Use these requests of information to document queries if the response changes scope and you have it in writing as evidence. Obtain written orders. Politely insist on a written variation order per the contract before proceeding. This could be as simple as an email from the superintendent saying, proceed with variation 5 as discussed, estimated cost X. It's just something traceable. And point 5, really important, document everything. Maintain a variation register, logging the variation number, the description, who ordered it, the date, any reference documents, cost, time, impact status, whether it's pending, approved, or rejected. This helps track all the changes in their resolution so nothing falls through the cracks. Documentation and record keeping. For each variation, keep supporting documentation. This includes drawings, sketches of the change, correspondence, and internal memos. Also record the labour, materials, equipment used, and if it affects cost, this will support your valuation. Cost coding. Use separate cost codes for variation work in your accounting job cost system. This isolates extra work expenses from the base contract work, making it easier to compile claims and demonstrate costs incurred due to variations. Photographic evidence, if applicable, take photos of the work before and after variations, especially for latent conditions or client-requested design changes. Visual evidence can be persuasive in explaining why the extra work is needed. Daily logs. Site diaries and daily logs should note when work on a variation commenced and finished, and any downtime or disruption is caused. This not only supports the claim for the direct costs, but also any delay or prolongation claims arising from the variation. And use standard forms for variation/change orders. Even if the contract doesn't prescribe a format, have a consistent internal form with sections for the description, reason, cost, time, impact approvals. Ensure key information is captured for every change. So communication and collaboration, another 5 points. Early involvement. When a potential variation is identified, for example, a design change or an unforeseen site issue, notify the other party early. Open communication can lead to collaborative problem solving before a formal variation is finalised. Engage the owner in discussions about variations. Explain why a change is needed or beneficial and the implications of cost and time. This transparency builds trust and can lead to quicker approval or alternative solutions that suits both parties. Treat variation pricing as cooperative negotiation, not a zero-sum game. Provide breakdowns and justification for costs. This means the superintendent, owner, more comfortable approving variation and reduces the suspicions. Likewise, the contractor should entertain reasonable queries or alternative approaches to achieve the change effectively. If there is a disagreement about a variation, attempt to resolve it while the project is ongoing. Perhaps escalate to a senior representative. Variations left unresolved can often lead to becoming formal disputes, and tackling them in real time can save time and relationship damage. You should adopt a collaboration mindset. All parties should remember the common goal, and that is a successful project. Principals should not unreasonably deny or delay legitimate variations, and contractors should not exploit variations to gouge the principal. A fair and prompt approach by both sides ensures the project keeps moving smoothly. So, in terms of variation costs and pricing methods, the first resort for pricing a variation is often to use the rates in the contract. If the contract has a bill of quantities or a schedule of rates, see if the very work is similar to an existing pay item. For example, if adding 10 square metres of concrete, use the contract's metre square rate, or the concrete if reasonable. The standard forms, the AS2124 and 4000, specifically say use contract prices so far as they are applicable. If the variation is of a nature covered by the contract's rate schedule, then the rate governs the addition or omission. This ensures consistency and fairness. If a variation is for something not in the contract, then new rates must be established. Typically, the contractor proposes a rate based on actual cost build-up. The superintendent architect will review and either agree or determine a reasonable rate. So in many cases, especially under the ABIC or bespoke contracts, the contractor will submit a quotation for the variation. If the principal accepts, the agreed price is binding, and this is often preferable as it fixes the costs up front, avoiding later disputes about valuation. If the variation scope is uncertain or urgent, parties might proceed on a day work or time and material basis. The contractor keeps track of the actual labour hours, material and equipment, and gets paid the actual cost plus a fee. Contracts often have a schedule of day work rates, so hourly labour rates, when ordered in writing, and day work should be used with caution and documented thoroughly. So extensions of time, assessing delay variation can affect project timeline, determine if the change is on the critical path. Standard contracts link EOT claims to variations. Be mindful of concurrent delays. Sometimes, rather than extending the time, a principal may ask the contractor to accelerate or maintain the original completion date. And record and justify. Contractors should maintain schedules showing the impact of each major variation. Early negotiation or dispute resolution. It's important to have prompt discussions when a dispute arises over variation, though the first step is usually face-to-face negotiation. However, if that negotiation fails, consider bringing a neutral third party in, like a mediator or an expert determinator. Importantly, most contracts require a contractor to continue work despite disputes. So even if there's a disagreement, a contractor should not stop work and use both contracts mechanisms to segregate the disputed portion and keep the project moving. Document the issues for the dispute. If negotiations are happening, ensure all positions are documented in letters, meeting minutes, and this creates a record for what was discussed and any concessions offered. Some contracts have tiered dispute resolution clauses such as negotiation, then senior executive negotiation, then a mediation, and then arbitration and litigation. Follow these steps. Often a dispute elevated to senior executives or an independent mediator gets it resolved without needing to go to court. So security of payment, it's important to note that under the security of payment legislation, contractors have a fast-track route to claim payments for variations through adjudication. If an invoice or payment claim for a variation is not paid, the contractor can refer it to an independent adjudicator for a quick determination. So variations in SOP claims. So even if they are disputed, they still can be claimed. The Act usually allows for work done under the contract, which includes agreed variations and even disputed variations or quantum merit in some cases. Adjudicators will consider the contract and any writings and even estoppel arguments, but in a rough and ready way due to time constraints. So what are the pros and cons? The advantage of the security of payment process is cash flow. Adjudication yields a binding interim payment that the principal must pay. The downside is adjudication is summary, complex, variation issues might not fully get fleshed out, and either party might still litigate later to overrun an adjudication result. So if you're a contractor and a valid variation is not paid, the security of payment adjudication process is a powerful tool. It ensures your payment claims clearly identify the very works on the basis of the value. If you're a principal, be ready to respond with any reasons for non-payment. What's really important about the Security of Payment Act is to strictly follow the process. So timelines for payment claims and schedules. Many a respondent has been caught missing a deadline, resulting in the contractor getting the full claimed amount by default. Treat variation payment disputes with the same urgency as any payment dispute under the security of payment laws. So just to summarize and recap, variations are inevitable, changes will happen. Successful projects are those that manage changes effectively rather than deny their existence. The legal framework provides guidance, understand contract clauses and legal principles from cases that we spoke about like Berriman, Wigan, Chadmax. These cases arm you with the knowledge of what can and cannot be done when varying the works. Use precedents to inform your decisions. Process and communication. The technical legal rights are only half the story. The other half is process. Diligently follow your procedures for variations and maintain open communication with all stakeholders. Most issues can be resolved at the project level if handled promptly and fairly. And precise management equals fewer disputes. By managing variations with precision, meaning, clear documentation, timely notices, and respect for the contract, you greatly reduce the potential for disputes. Now, key takeaways: embrace the change management as a core skill in contract administration. It's about balancing flexibility and control, allowing the project to adapt flexibly, but within a disciplined framework. This balance leads to successful outcomes, even when the project scope evolves. Okay, feel free to share your experiences, how variations have been handled on your projects, what works well or poorly. This is an opportunity to learn from each other's real-world insights. And when to call a lawyer, really important. A contractor refers to an unapproved variation in a payment claim. A principal or superintendent rejects variation requests. Okay, that concludes the seminar today. If you have matter-specific questions, feel free to call the number on the screen or otherwise send an email to the email below.